Welcome back to The Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're talking about two cities in Washington trying to control how you store your guns. SB Tactical, the originator of the pistol stabilizing brace, set the bar for innovation and product development in the PDW pistol category. From the insanely popular SB M4 to the adjustable SB A3 and even kits for pump-action firearms, SB Tactical braces are available for a wide variety of firearm platforms in fixed, adjustable, and side-folding models. To get 15% off your legally transported and carried pistol braces, use the code TGC15 over at sb-tactical.com. Last month, two cities in Washington state, Seattle and Edmonds, each passed an ordinance titled An Ordinance Relating to the Safe Storage of and Access to Firearms. On July 18th, Seattle's mayor approved and signed the ordinance, making it effective on August 17th. Edmonds' mayor signed their ordinance on July 29th, making it effective on August 23rd. There were differing timelines on when the enforcement would begin. Now, let's get into what these ordinances actually say. Seattle's ordinance made it a civil infraction for any person to store or keep a firearm in any premises unless such weapon was secured in a locked container, properly engaged so as to render the weapon inaccessible or unusable to any person other than the owner or other lawfully authorized user. Because having a defensive tool that's easily accessible is somehow unacceptable in Seattle. It also stated the weapon shall be deemed lawfully stored or lawfully kept if carried by or under the control of the owner or other lawfully authorized user. The ordinance also made it a civil infraction if any person knows or reasonably should know that a minor, an at-risk person, or a prohibited person is likely to gain access to a firearm belonging to or under the control of that person, and then that firearm is actually obtained by one of those individuals. I guess that means you're supposed to know when somebody's going to steal your gun. Punishment is a penalty up to $10,000. Edmonds' ordinance was almost identical. Notably, both cities passed these ordinances in clear violation of Washington's preemption law. When you think about it, it's actually kind of comical. The politicians who claim we need more laws to stop people from doing bad things demonstrate how well those laws actually work by violating a law that's been on the books for 35 years. How's that for a heavy dose of irony?
And isn't it ironic?
You see, Washington law states the state of Washington hereby fully occupies and preempts the entire field of firearms regulation within the boundaries of the state, including the registration, licensing, possession, purchase, sale, acquisition, transfer, discharge, and transportation of firearms, or any other element relating to firearms or parts thereof, including ammunition and reloader components. Cities, towns, and counties, or other municipalities may enact only those laws and ordinances relating to firearms that are specifically authorized by state law and are consistent with this chapter. In other words, the state law supersedes local law, and municipalities can only regulate firearms consistent with what the state says. Now, at first blush, this may not seem evident why this is a violation of the state preemption law. But if you look closely, the ordinances clearly regulate the possession of a firearm, which is controlled by the state, not local municipalities. As you've likely figured out, such flagrant disregard for the law was not going to go unchallenged. Two individuals from each city, the Second Amendment Foundation and the NRA, filed suits against the cities seeking declaratory and injunctive relief. The suit states that the plaintiffs have a statutory right to be free from local interference with the possession of firearms, and that right's in jeopardy with the enactment of these ordinances. The proper relief, therefore, is for the court to declare that the ordinances violate the state's preemption law and issue an order preventing the cities from enforcing those ordinances. So, here we are again, another set of politicians stepping far out of their lane,
Stay in your lane,
in an attempt to regulate conduct that they don't have the authority to regulate, all in the illusion of safety. Now, what I want to know from you guys is, what do you think about this? Are safe storage laws a reasonable way to prevent tragedies from occurring? Or are they just another manner in which politicians seek to infringe on the Second Amendment? That's it for this episode. If you learned anything from the show, help us out and hit that like button. Make sure you share it with your friends. Don't forget to get subscribed, and if you enjoyed the video, consider supporting us via the links down in the video description. Be sure to check out the Gun Collective podcast Thursday nights on YouTube, also available on iTunes. And as always, thanks for watching. How was that?
It's good.
Seattle's ordinance made it a civil infraction for any Seattle's ordinance, any porpoise.
And then maybe one of these things, like a... Okay.
Don't use that one. All right.
The shirts worn in today's video on the Gun Collective have been provided by Patriot Patch. Closed captions have also been brought to you by Patriot Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.